So, we have decided to do a podcast.
Yeah. Well, you decided, and I went, yeah, that sounds good.
So, we have come up with the idea of dumb defenses, all sorts of weird law, and the weird legal theories behind them.
Well, because we're both lawyers, I
And
figure,
nerds, and ADHD, and all sorts of fun stuff.
once again, just lawyers. If you had a Venn diagram of all that,
It'd be a circle.
lawyers, it'd just be one circle. It's
Absolutely.
it's like people who love Renaissance fair, polyamorous people, and people who are into BDSM, circle.
Right. I, I found myself wondering the other day whether I have just managed to surround myself with all neurospicy people, or whether there's a weird ass apartheid with neurotypical people on top of it.
I don't know what they're doing. I don't think they're having as much fun as we are.
No, not at all.
So, do you wanna go first? Or do you want me to
Sure, I
go
will
first?
go first.
Okay.
Okay, so I kind of have a twofer for you because
Uh-huh.
one got cited in the other, and so
Sure.
needed to go over the one to make the other one make sense. So, these are contracts, which is not super fun sounding, but it will be more fun sounding. So the first case is Carlisle versus the Carbolic Smokeball Company from 1893.
Wait a minute, I've heard of this one.
It's a law school case. It's a law school case. So you might be asking, what the fuck is a smoke ball? It's essentially a little ball, a little like rubber ball with carbolic acid in it, and a little like puffer on top, so you could
Oh, that sounds safe.
kind of like super old school inhalers.
The carbolic smoke ball was a 19th century health scam.
Yes,
Okay.
but they put their money where their mouth was. They put out an advertisement saying a £100 reward will be paid by the Carbolic Smokeball Company to any person who contracts the influenza after having used the ball 3 times daily for 2 weeks, according to the printed directions supplied with each ball. £1,000 is deposited with the Alliance Bank, shewing our sincerity in the matter. Okay? So then Mrs. Carlisle decided, hey, I could use £100, which, by the way, £100 in 1892 money is £16,492 today, or $21,976.87. So,
Okay, all
not a
right.
small amount of money.
Yeah, that's a significant chunk of change right there.
Okay. So, one thing that I found kind of weird just about how this was written, in American law, at least modern American law, they're always talking about, like, the court says this, the court says this. All these judges wrote in the first person, and I found it really off-putting for some reason. But essentially, Mrs. Carlisle used the ball for whatever it was, 3 times daily for 2 weeks, and still caught the flu.
I
And
bet
so she wanted her $100
I
or
bet
one
she was
hundred
out
pounds.
there like licking doorknobs and influenza season. She's like, I want $20,000. I just got to get the flu.
Right. The court in that case determined that because that £1,000 was put aside to pay people who actually did the challenge, that it wasn't mere puffery, and that essentially the advertisement was a I dare you to type thing. The advertisement clearly offered to anybody who performed the conditions, and by performing the conditions, they accepted the offer. The notice of accepting the offer is the doing of the thing. That's kind of how advertising generally works. Like, you go to the Gap to get a BOGO, like their advertising BOGO, you say, I accept the offer, here are the pants that I want to buy, right? They went through this whole analysis about time limitations and what is a reasonable time. There wasn't really a time limitation in the advertisement, which then gets, of course, construed in the light most favorable to the contractee. Only 3 possible timelines in this. It's either limited to people catching the prevailing epidemic or any colds during that time frame, which the court kind of wrote off as they're not going to talk about that. Or you're warranted from catching the epidemic or other colds or diseases while using the remedy after using it for 2 weeks, which is plausible, in which case Miss Carlisle would win. Or for any person who contracts the epidemic or other disease within a reasonable time after having used the device, which is what the court ultimately settled on as the timeline for people who are eligible for this reward, looking at a reasonable time of how long it takes the germ to develop, or a business sense, but also, again, landing on the plain language of the advertisement is how they wanted to do it.
So I mean, like, this is taking me back to contracts because
It should. It was a case that probably
yeah,
everybody who's done contracts has read.
yeah, the mere puffery. As soon as you said that, it brings you back because so a contract, in legal essence, is that there is some offer for some kind of consideration,
Correct.
and you have to manifest. You have to accept, and there's different ways to accept a contract,
Yep.
and in this case, one of them is just doing it.
Just doing the thing.
I'm concerned, like, what was in the carbolic
It's
smoke.
carbolic acid.
Carbolic acid is toxic. I mean, this is real
It
classic.
is, but it's also toxic to the germs.
Well, this is people drinking bleach to get rid of
Yes. Yes. So
COVID.
in terms of consideration, the court rejects the idea that there is no consideration for it, and rather they decide that the benefit to the manufacturer is the sale of the device, and then the burden on the recipient is conforming to the instructions, and so that is sufficient. You know, a peppercorn will do, as they say. So they concluded that Miss Carlyle was entitled to her £100.
She gets
And
20 grand.
she gets her 20 grand, and there's this great quote that the defendants must pay her, quote, if they had been so unwary as to expose themselves to a great many actions, so much the worse for them. The court essentially says, boo on you.
Yeah. Bummer. Sorry. Was this Spanish flu time?
Yes.
Okay. Well, I mean, good for Mrs. Carlisle.
Yes. So that is our background.
Okay. So the
Because
carbolic smoke bomb
because the
case.
next case actually cites that. So,
Is this the fur coat case?
no.
No. Okay.
Leonard v. PepsiCo Incorporated from 1999. I actually remember when this happened.
Is this the guy that bought all the Pepsi and tried to get the airplane?
Yes.
Yes.
So,
Airplane guy.
the court actually does a beautiful job describing the commercial, so I'm going to read their description of it because it's hilarious. Okay. The commercial opens upon an idyllic suburban morning where the chirping of birds and sun-dappled trees welcomes a paperboy on his morning route. As the newspaper hits the stoop of a conventional two-story house, the tattoo of a military drum introduces the subtitle, Monday, 7:58 a.m. The stirring strains of a martial air mark the appearance of a well-coiffed teenager preparing to leave for school dressed in a shirt emblazoned with the Pepsi logo, a red, white, and blue ball. While the teenager confidently preens, the military drum roll again sounds and the subtitle, T-shirt, 75 Pepsi points, scrolls across the screen. Busting from his room, the teenager strides down the hallway wearing a leather jacket. A drum roll sounds again, and the subtitle, Leather Jacket, 1,450 Pepsi points, appears. The teenager opens the door of his house and, unfazed by the glare of the early morning sunshine, puts on a pair of sunglasses. The drum roll then accompanies the subtitle, Shades, 175 Pepsi points. A voiceover then intones, Introducing the new Pepsi Stuff catalog, as the camera focuses the cover of the catalog. The scene then shifts to 3 young boys sitting in front of a high school building. The boy in the middle is intent on his Pepsi Stuff catalog, while the boys on either side are each drinking a Pepsi. The 3 boys gaze in awe as an object rushing overhead as the military march builds to a crescendo. The Harrier jet is not yet visible, but the observer senses the presence of a mighty plane as the extreme winds generated by its flight create a paper maelstrom in a classroom devoted to an otherwise dull physics lesson. Finally, the Harrier jet swings into view and lands by the side of the school building next to the bicycle rack. Several students run over, and the velocity of the wind strips one hapless faculty member down to his underwear. While the faculty member is being deprived of his dignity, the voiceover announces, Now, the more Pepsi you drink, the more Pepsi stuff you're gonna get. The teenager opens the cockpit of the fighter and can be seen, helmetless, holding a Pepsi, looking very pleased with himself. The teenager exclaims, Sure beats the bus, and chortles. The military drum roll sounds for one final time as the following words appear. Harrier fighter, 7 million Pepsi points. A few seconds later, the following appears in a more stylized script. Drink Pepsi, get stuff. With that message, the music and the commercial end with a triumphant flourish.
But in this case, the court comes to a different reasoning because it's not legal for a citizen to own a Harrier jet,
Well,
right?
that was kind of part of it, but it was actually it was more basic than that. So essentially, what happens is this kid sees the commercial and wants to get the Harrier jet. So the Pepsi Stuff catalog had 53 different items, not including a Harrier jet, and said that additional Pepsi coins could be purchased for 10 cents each, but you need at least 15 original Pepsi points for each order. So you could essentially like put in 50 Pepsi points and then pay to get like the leather jacket or whatever. So the Harrier jet was not on the order form, and so the kid wrote in one Harrier jet in the item column and 7 million in the total points column and mailed 15 original Pepsi points and a check for $700,008.50 with the assistance of counsel. Try to get the Harrier jet. Pepsi responded. The item you have requested is not part of the Pepsi Stuff collection. It is not included in the catalog or in the order form, and only catalog merchandise can be redeemed under this program. The Harrier jet in the Pepsi commercial is a fanciful and simply included to create a humorous ending to the ad. We apologize for any misunderstanding or confusion that you may have experienced and are enclosing some free product coupons for you to use.
And so, like, this kid sues.
This kid sues. His attorney writes back, "Your letter of May 7th, 1996 is totally unacceptable. We have reviewed the videotape of the Pepsi Stuff commercial, and it clearly offers a new Harrier jet for 7 million Pepsi points. Our client followed your rules explicitly. This is a formal demand that you honor your commitment and make immediate arrangements to transfer a new Harrier jet to our client. If we do not receive transfer instructions within 10 business days of the date of this letter, you will leave us no choice but to file appropriate action against Pepsi."
If I'm recalling correctly, like this case, this kid's like, okay, a Harrier jet's worth $10 million. And you can purchase Pepsi points for 10 cents a piece as long as you have purchased 15 Pepsis and you turn in like the actual Pepsi points.
Right.
So the court was, if I recall, unimpressed by this clearly devised way to set up a lawsuit.
Yeah. So the letters went back and forth. Letters went all the way up to the VP of the company, who was like, "I find it hard to believe that you're of the opinion that it really offers a Harrier jet. Like, nobody's impressed with this kid." There was some forum shopping chicanery that happened
Forum shopping for
to try and get like the best.
yeah.
Whatever.
For my mom who's listening. Was
Like,
trying-
it wound up in Florida at one point. Kid lived in Seattle. Pepsi, I think, is probably headquartered in New York, just because the statute of frauds got brought up at one point. And so, like, this kid is purposely filing in districts where it doesn't belong in order to try and get the best outcome. Regardless, winds up in summary judgment, meaning that Pepsi was like, there's no issue of material fact here, and we win on the law. Kid argues carbolic smoke ball because, well, in that situation, there was, the offer and consideration was just part of the whole thing. The court says no. They apply a reasonable or objective person standard, which is, something we have to do in lawsuits like this, and said no objective person could reasonably have concluded that the commercial actually offered a Harrier jet, and it was an obvious joke.
Yeah.
The court then had to explain the joke.
I mean, I love it when they do that, when they're like, the joke is that it's such this big thing and it was knocking the teacher's clothes off. And what level did this make it up to in court? It was like,
I think this was just trial level. It was a very long decision for a trial level.
I mean, you can tell when they're having a good time with it. And also when they're just they know that other people are going to read this lawsuit. But this was a circumstance where this kid had clearly set it up to say, like, I've done the math, and I think, like, got backers or sponsors for this lawsuit because they're like, at the very worst, they're just not going to take our money. We're not out any money. And at the very best, we're going to get the value of a Harrier jet in the
Right.
millions of dollars.
Yeah.
And it just
Yeah.
didn't work.
Right. And so they included a quote from E.B. White that said, "Humor can be dissected as a frog can, but the thing dies in the process," which is so true. They labeled the commercial as having zany humor. The lettering on the screen was meant to evoke military espionage thrillers, so Pepsi stuff will inject drama into the hitherto unexceptional lives to show how exaggerated it is. They do say that this is, in fact, mere puffery, as opposed to the Carlisle case. The youth in the commercial is a highly improbable pilot who could barely be trusted with the keys to his parents' car, much less the Harrier jet, which is they called the prize aircraft of the United States Marine Corps. He spent his pre-flight minutes preening and flies without a helmet rather than following safety protocols. There's a youth statement of "it sure beats the bus," which they said evidences an improbably insouciant attitude towards a relatively difficulty and danger of piloting a fighter plane in a residential area.
I've got a similar one. I've got a real estate contract case for you
Oh my god.
from late 80s, early 90s. So it was
Okay.
actually decided by the New York Supreme Court.
In New York, the Supreme Court's the trial level court. It's fucked up.
New
Yeah.
York. No, it's an appellate court case. Sorry,
Okay, so it's the mid-level.
mid-level court. So this went through trial court. I mean, in the decision, it does reference the lower court. So I knew it had been through at least one.
What our civil procedure professor would tell us is that it's the Supreme Court because it has supreme jurisdiction over everything. And I'm like, cool, bro. The rest of the country thinks otherwise.
Yeah. All right. Picture it. 1991. There is a person shopping for a nice waterfront house in New York and finds ones that he likes and says, "I would like to buy this." Talks to the real estate agent. This is where things get interesting. The real estate agent goes back to the seller and says, "This person would like to buy your house." And the seller says, "I'm not going to agree to this real estate transaction unless you tell the prospective buyer that the house is haunted."
Weird, but okay. Are they
Weird, but
actually
okay.
trying to sell the house, or are they just trying to look like they're selling the house?
They're actually trying to sell the house. The real estate agent goes back and says, "All right, well, the seller won't sign this contract unless you know that the house is haunted." And the buyer laughs it off, signs the contract, and puts down earnest money in the amount of $32,500, which in today's money is worth about 80 grand.
Yeah.
And they're all about their merry way. Then the buyer goes and talks to the seller. And after talking to the seller about the activity that was occurring in the house, the buyer immediately tries to rescind the contract and get their earnest money back.
Because the house was actually haunted.
Well, according to the lower court, the house was actually haunted. As a matter of law, the house was haunted. The appellate opinion, I really encourage you to read because there's some real gems. You can tell that the Court of Appeals was having a great time. They quote Ghostbusters, couple lines of Shakespeare. They have ghost references all the way through it. But let's talk about the law of the case. So, in New York at the time, the law of real estate contracting is caveat emptor, buyer beware.
Mm-hmm.
But the Court of Appeals decides that the buyer can rescind the contract and get their earnest money back and does not have to follow through with the sale of the house, which is what the seller wants. So in this case, the buyer is Mr. Stambovsky and the seller is a Ms. Ackley. Ms. Ackley, prior to deciding to sell her house, has made it very well known to the community and even to Reader's Digest that the house is haunted, that it has poltergeist activity. She talks to the local paper at least 3 times. Like I said, she talks to Reader's Digest, and she includes her home on a local house tour of haunted houses and tells stories of things moving, of her daughter being shaken awake from bed every morning, makes jokes about not needing an alarm, but is
They
happy,
want to make sure they get to school on time.
but she's happy that the the poltergeist isn't waking her up every morning and that she can sleep in. So she's made no secret of it. Like she's advertised it, it's gone out into the community. And so, thinking of this first lawsuit, we don't know what Ms. Ackley says to Mr. Stambovsky to make him so freaked out. Because before that, he had a real estate agent tell him, hey, this house is haunted. And he was like, ha ha ha. He goes and talks to her, and this guy wants completely out of the entire deal.
Because now it's actually haunted.
Well, we can only guess, and I like to think that she scared the absolute bejeebers out of him. She seemed pretty content with this house. It's a nearly 4,000 square foot waterfront house that Ms. Ackley and her husband had bought years prior in very poor condition and had been of interest historically, like the locale for Revolutionary and pre-Revolutionary War maneuvering and battles and all kinds of other stuff. But this guy wants out. The best thing that comes out of the lower court is they say, as a matter of law, the house is haunted. And they make,
Imagine being the trial judge being like, really?
yeah,
I have to decide this?
they make that ruling because Ms. Ackley had been so public about it. So it's like, hey, we cannot argue that the house is haunted. But there have been a lot of other cases in New York prior to this, and the laws, I understand, have changed quite a bit. Ms. Ackley appeals. And the appellate court
She
has
appeals because she doesn't want it to be haunted?
no, she appeals because she wants to force the sale of the house
Ah.
to go through or to retain the earnest money. I've got a couple of good quotes. While I agree with Supreme Court that the real estate broker, as agent for the seller, is under no duty to disclose to a potential buyer the phantasmal reputation of the premises, and that in his pursuit of a legal remedy for fraudulent misrepresentation against the seller, plaintiff hasn't a ghost of a chance, I am nevertheless moved by the spirit of
Oh my
equity to
god.
allow the buyer to seek rescission of the contract sale and recovery of his down payment. A little bit further on, therefore, the theoretical basis for granting relief, even under the extraordinary facts of this case, is elusive, if not ephemeral. So they are really trying to to jam as many ghost references into this as possible. But what they really come down to towards the end of the case is this caveat emptor is like, hey, buyer beware. And the buyer has this tremendous responsibility to
Yes.
examination. However, the best examination in the world could not have revealed that that house was haunted or the reputation of the house being haunted. And so the court,
Even though she was like super public about it?
to her local community, towards the end here. In the case at bar, defendant Seller deliberately fostered the public belief that her home was possessed, having undertaken to inform the public at large, to whom she has no legal relationship, about the supernatural occurrences at her property. She may be said to owe no less a duty to her contract vendee. And the court kind of reasons that she had a duty to tell, and kind of reasons that the buyer could not have known that her muckraking about her own house would have made it less valuable, and that he didn't know that it had this reputation. The court ruled that she had created this bad reputation for the house, making it less valuable. But that's not all the court says. At no point does the lower court or the appellate court ever say the house is not haunted. The lower court says this house is haunted as a matter of law, and the appellate court goes on and references that a number of times. So this is a case where two courts, the Supreme Court, which is the lower court, and the appellate court of this great state of New York, determined that a house was haunted. Now, this case got a ton of publicity.
I bet.
And after the rescission, so the buyer gets his money back, gets to walk away from the case. He had also sued for false representation of his agent, but that got dismissed.
It's like they were pretty clear that it was haunted. Like, how is there a false representation?
Well, like the reputation for it being haunted. Anyway, it's just a fun case. Here's a rare real estate case, apparently from the time, where the buyer gets his money back and gets to walk away. But in the aftermath, there was a ton of publicity about this case, about how the court ruled that this house was haunted. You can imagine what the papers said at the time. Mm-hmm. And this lady pretty much immediately gets 25 offers for her house. And one of them from a famous spiritualist person. She winds up selling it to a different person and moving to Florida, and later dying. And after her death, her son was interviewed, where he says that now he has no doubt that his mother is haunting the house, this supposed poltergeist house.
The one in Florida, or the
one in New York? So that her...
That's a bit of a trip for a ghost to make.
I mean, who knows what's happening in the astral plane. So there is a house that has gone through a couple of famous people's hands. It was once owned by Ingrid Michaelson, the singer, that is, according to the courts of New York, is a haunted house.
That's wild.
Yeah. And I thought you would enjoy Stambovsky v. Ackley.
That's such a good name, Stambovsky.
Which you can read at NY AppDiv 1991 if you wanted to look it up. It is honestly, legitimately a fun read.
That's awesome. There are some other fun quotes in the Pepsi one when they were trying to dissect and therefore kill the humor of it. Traveling to school in a Harrier jet is a, quote, exaggerated adolescent fantasy. Blowing the clothes off the teacher is literally defrocking an authority figure. He parks the jet next to a plebeian bike rack. So they also had some fun with language in this one. No school would provide a landing space for a student's fighter jet or condone the disruption the jet would cause. In terms of the price, we touched on this a little bit. To amass 7 million Pepsi points is approximately 190 Pepsis per day for the next 100 years. The actual cost of the Harrier jet in '99 was $23 million, which is almost $45 million today, so the deal was too good to be true. The kid tries to say there's no difference between the jet versus anything else in the commercial, and the court's like, this is obviously absurd. No.
I mean, there's that, hey, obviously absurd. What's the difference between a jacket and a Harrier jet? I mean, who knows? I just wanted all the jet, and Pepsi never cashed this kid's check. Right. I think it would have been a different thing if they say, like, we have a Harrier jet and here it is, or they cashed his check and then tried to send him 1,500 jackets.
Right.
But
no, they didn't. And in fact, the letter from the VP of advertisement read, I find it hard to believe that you are of the opinion that the Pepsi Stuff commercial, hereinafter commercial, really offers a new Harrier jet. The use of the jet was clearly a joke that was meant to make the commercial more humorous and entertaining. In my opinion, no reasonable person would agree with your analysis of the commercial.
And no reasonable person did. Even this kid knew it was unreasonable. That's why when he sent off for the jet, he already had a lawyer.
Yeah, 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 yeah.
He's
Yeah.
got some schmuck. I mean, let's defend the Carbolic Smoke Company, though. I think today this might be a winnable case because Mrs. Carlisle would have to prove that she indeed had the flu. She would
Right.
have to prove that she indeed had used the product as directed for a minimum of 2 weeks before contracting the flu. I mean, there's other ways they could
Well,
have
and
got
there,
it.
I mean, we've got a whole lot more technology and stuff now that we could, like, back then, like, if you got the sniffles, everyone was like, oh my god, it's the flu.
It's the flu.
But now, the entire office can come down with COVID, except for my husband who wound up having flu. A lover's quarrel for you next time.
Next time we go to pre-Renaissance era France. I will see you then.